Welcome back. I'm attorney Thomas Burton, and today, in the latest episode of Estate Planning 101, we're going to be discussing how to avoid frozen bank accounts at death. So, welcome back to the series. As you know, Estate Planning 101 is my long form educational series where we cover various estate planning topics. And this topic of frozen bank accounts I see come up quite often at my office in the context of when someone has passed away, the heirs or person are notified that the bank accounts have been frozen and what can they do about it. So let's talk about it from an estate planning perspective, why this happens and how you can avoid it. So here on the legal pad, I've got a little person here, that's you. And we're going to look at you during your life often open a bank account in your individual name, John Smith, checking and savings account with your local bank. So the bank has a relationship with you. Your signature is required to write a check or deposit or withdraw money. And you're generally the only one the bank has privity with. The contract is between you and the bank. So then what happens when eventually, sad to say, you pass away? Well, the default option is the bank freezes the account. Why? Because you are dead and there's no one left to tell the bank what to do. So then the safest thing to do and under the law is freeze the account and wait to hear what's supposed to happen to them. So generally, the bank will ask you for domiciliary letters appointing a personal representative. And to get these, you need to go to the probate court, generally in the county where the deceased person died when they passed away. And the bank is going to say to you, we want those domiciliary letters. We don't know who's in charge, so we're freezing the account until you get them. When you get those letters and get appointed as personal representative, then we will be directed by the court as to what to do. So in Wisconsin, we call what other states call an executor, we call a personal representative, and that's the person appointed to administer your estate. Now, if you have a will, you perhaps made a choice for personal representative. If you don't have a will, then one of your heirs under the intestate statutes would have to petition to open the probate court process to get appointed as personal representative. And just as a reminder, there is no simple method for, let's say all you have is one bank account. It doesn't matter. The probate court process is the same whether you have multiple pieces of real estate in a bank account or just one bank account. They're going to have to go through that process to get it open. And you should plan to spend 6 to 12 months or more in the probate court process for your personal representative. So getting those domiciliary letters, they also are unlikely to get them in a matter of days. It's going to be more generally weeks to get appointed as personal representative. So in Wisconsin, the small estate limit is currently $50,000, meaning if you have more than $50,000, $50,000 and $1 or $50,000 or more in probate assets, you go to probate court, whether you have a will, with a will, or no will. Dying without a will is intestate. So unless you've set up a method to avoid probate completely, such as using a revocable living trust, if you're over this limit, you'll go to probate. If the bank account is under $50,000 and there's no other assets that put the total over $50,000, like a house, a car, personal property, then there is a simplified transfer by affidavit method just that can be used for a bank account. So your bank may include this in their letter to you, or they may not. Some just say they want the personal representative letter. A lot of banks don't like working with those, but it is a method if you're under the $50,000. But for a lot of people, they're going to be over that limit, and that's what we're discussing today. If there's more than $50,000, and again, it can't just be $50,000 in that account. Let's say $40,000 in the savings, $40,000 in the checking, and $40,000 in a CD. That's over the limit because the total is over $50,000. So the whole total of probate assets would have to be under 50,000 to use the simplified method. So as a reminder, after death, the bank has no relationship with your heirs or whoever you've named in the will, or if you didn't have a will under the intestate statutes. So the safest thing for a bank to do is freeze the account and wait for direction. Because as you know, banks don't want extra liability, and they're not going to just trust you if you come down and say, I am the only heir, give me the money. That's where they're going to say, go to probate court and prove it, then come back with all the paperwork. And then generally you would open a new estate account, which becomes its own account to administer the estate. So we've got two options to avoid this frozen bank account problem. And I'm going to go through both of them and give you my thoughts on each. The two options are to set up a trust during life and retitle your accounts into the trust, or name a payable on death beneficiary on the accounts. So let's run through the trust option first, because that's my preference. It's the most flexible and gives you the best protection. So a trust set up during life can outlive you. That's the great thing about a trust. See, everything else dies when you die. The power of your agent under your power of attorney dies when you die. The power to access bank accounts, even if you put someone on there as a signer, dies when you die. So the Smith Living Trust, for example, you set up during life, that's the living part, and it can outlive you after death. Then inside the trust document, you name a successor. So you say, I am the trustee during life, but upon my death or incapacity, I name my son Joe Smith to take over. So the great thing is the bank often won't know you're dead until someone tells them. But Joe Smith could say, my father, John Smith, passed away, but here's the trust. And you can see, bank, the accounts are already in Smith Living Trust. And here's the trust document. I am the successor trustee. So then the trust can instruct the successor to pay all bills of last illness, funeral expenses, etc. The trustee can do this as a private administration. They don't have to go to probate court. And then the successor distributes the funds to the persons named in the trust. So you control who receives the assets, and inside your trust itself, you name then who would receive them. So it doesn't mean your son Joe has to get everything. It just says Joe's in charge of distributing it amongst Joe and his two siblings, for example. So the trust option, in my opinion, is the best because it protects you during life. The successor trustee can take over even if you're incapacitated. So that's a situation where you're alive but unable to pay your bills, a period of incapacity, think coma or Alzheimer's, something like this. So the other option then is, under the law in Wisconsin, you can make your accounts payable on death to a beneficiary. And this, I believe, is allowed in most other states as well. You can name one or multiple payable on death beneficiaries. And this P.O.D. is the short form version you'll see for that payable on death language. In my opinion, it works best for a smaller estate and a small number of beneficiaries. So if you had one child and you want everything to go 100% to the child, this could work to name them as the payable on death beneficiary, because there's no one to fight with over things, and it's a very clean 100% to them. The downside is there's no incapacity protection on a payable on death. It only kicks in when you die. So if you're incapacitated, it's not like having a trustee who can take over management of the accounts. There's no instructions to pay funeral bills, debts first, like there could be inside the trust. It just pays out directly to the beneficiaries. You also must keep these updated because they override any will or trust. So if you name two people here and then you later change your will or trust, the bank is going to go by the payable on death beneficiary because that's a contract between you and the bank. Or let's say you name an ex-spouse or something. You need to keep those updated. So if you use this method, just make sure that's updated whenever your mind changes on these things. In contrast, if you have it in the trust, everything flowing through the trust, you can do one amendment to change the trust dispositive scheme, and that would apply for everything passing through the trust. So the payable on death beneficiary can work to avoid probate. It's certainly a well-used probate avoidance device. And if you don't have a trust or a will or anything, if you don't have a trust for sure, anything set up, payable on death on the bank account will help you avoid probate on those assets. The thing I don't love about payable on death in a bank account is generally they're going to be using it for naming 2 or 3 people, and if you're getting into naming dozens of heirs or charities or beneficiaries, it's a bank form you use, so check with your bank and see if they would allow naming that many. The other thing is they're going to just strictly pay out whatever the balance is to those people named. And again, there wouldn't be a provision in there to pay your funeral bills or expenses first. So you might think if you're leaving it to your children, they would go ahead and pay those out of their share. But it depends, you know your children best, so you never know. Whereas if you use the trust method first, you can make sure the trustee pays all your bills before splitting the assets at the end. So the trust is more flexible, provides for more management responsibility, but both methods, retitling bank accounts to a trust during life or payable on death to a beneficiary at death, will avoid probate on your bank accounts at death and will avoid this problem of frozen bank accounts upon death. Because remember, the relationship is between you and the bank, and when you die, that relationship is severed, and that's generally what leads to the bank freezing those accounts. So I see this come up, unfortunately, quite often, and then people often are a little bit stressed because someone just passed away and they're thinking about getting the money to pay for the funeral and the flowers and the meal and the burial and things like that. And having those frozen bank accounts right there in that period when they're grieving can be a difficult thing. So if you're thinking about your own estate planning, consider looking at ways to make it easier on your heirs by avoiding those frozen bank accounts at death. And this video should give you the great options to do so. So thanks for tuning in, thanks for watching, and we'll see you next time.